Welcome, the National Right to Work weekly wrap-up for the second week of February. As usual, it has been a very busy week with action in Indiana, Ohio, Washington, D.C., California, and Massachusetts. We begin with Ironworker organizers' threats and bribes in an attempt to goad employees into supporting their union. In Toledo, Ohio, with the help of National Right to Work Foundation staff attorneys, a NOVA Services employee filed charges against the Ironworkers union for offering bribes and threatening employees. 15 other NOVA Services employees have also retained Foundation staff attorneys to represent them in this matter. In August 2012, a union official told employees at an organizing meeting that he could provide them with legal immigration status in exchange for supporting the union. Union operatives also made similar offers to at least 6 employees. Later that month, union officials threatened to file immigration violation complaints against the employer if employees failed to support the Ironworkers organizing drive. The charge details how union organizers also resorted to outright bribery to obtain employee support. In August, one union organizer offered a worker $50,000 in exchange for supporting the union's campaign. The charges will now be investigated by the National Labor Relations Board. Mark Mix, president of the National Right to Work Foundation.
The union's strategy in this case emphasizes the need to protect the secret ballot election, to protect workers from the coercion and intimidation that exists in these card check campaigns. And so we have to continue to defend workers' right to choose free from this type of intimidation.
In Indiana, National Right to Work Foundation staff attorneys filed a federal unfair labor practice charge for an AT&T employee, James Dawson, against a Communications Workers of America union for discriminating against him for exercising his rights under Indiana's new right to work law. The unfair labor practice charge was filed at the National Labor Relations Board regional office in Indianapolis. Mr. Dawson resigned from membership in and exercised his right to refrain from paying dues to the Communication Workers of America union. Under Indiana's right to work law, which was enacted in early 2012, Dawson and other private sector workers have the right to refrain from union membership and dues payments. The charges included union discrimination against the employee because he exercised his right to refrain from union membership and that union officials made an example of him to intimidate his coworkers. In Ohio, nurses get sold out when their employer who resigned a neutrality agreement with union officials rather than allowing the nurses to decide representation free from harassment. 2 nurses filed a motion with the National Labor Relations Board seeking to intervene in a federal case in which the NLRB is attempting to force union representation on the nurses in the wake of a tainted organizing election. With free legal assistance from National Right to Work Foundation staff attorneys, the Affinity Medical Center nurses filed the motion last week. A union group calling itself the National Nurses Organizing Committee entered into a neutrality agreement with Affinity Medical Center Management Company, and union officials refused to disclose the terms of the secret agreement despite repeated requests from the nurses. The 2 nurses point out that the secret deal between Affinity and NNOC union officials, combined with the intimidation of nurses who spoke out against unionization, likely affected the outcome of the union organizing vote. Caught between union bosses and corporate executives, these nurses have been stripped of their rights to oppose forced unionism in their workplace.
Caught between union officials and corporate executives, nurses and medical professionals should not be subjected to this type of infringement upon their rights in the workplace. These nurses have courageously stood up in an effort to make sure their voices are heard and their rights are protected, which they're supposed to be under federal labor law. The National Labor Relations Board, as currently constituted, is making a sham of Section 7, which is supposed to protect individual workers' rights against forced unionism instead of empowering union officials or corporate executives to force workers into unions.
Foundation attorneys forced the Service Employees International Union to clean up its act after union officials falsely claimed to represent Boston, Massachusetts, complete cleaning employees. In fact, the employees had nearly unanimously opposed SEIU. In an attempt to force their employees into contract talks, SEIU filed federal charges against complete cleaning workers. Workers there feared that SEIU officials would have illegally obtained a forced union dues contract against their will. National Right to Work attorneys won a settlement that requires SEIU union officials to stop trying to claim monopoly bargaining powers over the workers. And in Washington, D.C., Ray LaJeunesse, Vice President and Legal Director of the National Right to Work Foundation, testified in a congressional hearing about the National Labor Relations Board and its numerous rulings against workers during the Obama administration. LaJeunesse, who has over 40 years of experience on the foundation's legal staff and has argued 4 cases before the U.S. Supreme Court, repeatedly criticized the National Labor Relations Board for its lax enforcement of the rights of workers who wish to refrain from union affiliation. LaJeunesse pointed out that the board has permitted union officials to erect a number of bureaucratic hurdles that discourage independent-minded employees from asserting their rights. LaJeunesse highlighted the NLRB's board's recent holding that non-union employees can be charged for organizing activities and political lobbying for goals that are germane to bargaining. This elastic interpretation of the Supreme Court's Beck standard undermines the ability of non-union employees to refrain from funding ideological and organizing activities they may disagree with. Thank you again for your interest in the National Right to Work's ongoing battle against forced unionism. Please visit nrtw.org for information about these cases and to inquire about free legal services.